And the Lagos State High Court has released 3 inmates who had been held in detention without trial for about 6 years. Ben Abraham, a lawyer and founder of Zeraphat Aid, a non-governmental organization specializing in criminal justice, disclosed that these individuals were imprisoned without formal arraignment or given the opportunity to defend themselves. Mr. Abraham explained that his organization was compelled to intervene in the matter, filing fundamental human rights enforcement applications for each inmate, which eventually resulted in the admission of the documents by the court and subsequent order for their release.
13th day of November 2023, the High Court here in Lagos granted the enforcement of the fundamental rights of these 3 applicants, which we brought before the court. They've been in detention for about 6 years. The oldest of them has been in a Kirikiri Medium Custodial Center since 2018. For sundry offenses, they were awaiting the DPP's advice since then, but none came. So when we got to the Custodial Center and saw their plight, their cases were not going on, there was no trial, they were not even arraigned formally, before any court, talk less of having the opportunity to defend themselves. So we took up their cases, we filed a fundamental rights enforcement application for each of them earlier this year, and today, graciously, the courts ordered their release, upheld our submissions in the application, and directed that they immediately and unconditionally be released from custody after about 6 years without trial.
When I came to Lagos, I came to hustle just to make sure that I have something good doing in my, to myself. When I walk around, I see nobody to help me. I just go along and be doing hard boy. From there, I found myself doing what I don't want to do. So then I now,
what brought you here?
It's a defilement that as is the thing that brought me to Kirikiri Medium, and I was there since 2019. February 1st. I've never been going to court since February 11. Today, God performed his miracle in my behalf.
It says the mercy speaking. Actually, I don't do it, but actually today, the way I just see myself today, I see myself, God set me free today.
I've been here is January 2018. I've been in custody since 2018. But that I never go court since 20 again. I thank God for my life since when I entered that place. I tell God, say, now God, now bring me come this place. Now I that God, now go deliver me from inside this prison.
Well, that's how it feels to breathe the air of freedom after a long while. Now, to explore that matter further, we are now being joined here by Ben Abraham, a lawyer and founder of Zeraphat Aid, to talk us through what the successful case represents at this time for those clamoring for the congestion of the nation's correctional centers, as they are now known, and to what extent a more committed implementation of the Administration of Criminal Justice Act can help in this direction. Good to have you on the morning show. Thank you so much for joining us on the program.
Good morning. It's my pleasure to be here.
Yes, good morning to you.
Well, first, let's start with a little more detail, about these men that we just watched. They were released after like 6 years in custody without trial. How did you get involved in this case?
Okay, as an organization, we've been in this for about 20 years now. Part of the tools we apply in achieving reforms in the criminal justice sector is legal aid, offering free legal services, especially to indigent inmates who are not able to secure normal legal representation. And to gather this, to get this group, we have to visit the custodial centers, get there with the help of the various departments. We're able to sift through the mass of people who are waiting trial there, and then get these ones. So recently we did that. We do that periodically, and by the time we saw this group, of course there are more people than these 3 who are going through the same thing, the same ordeal. Then we had to, we observed especially that they were not attending courts. There are matters at the type that the DPP's advice has to be issued by the DPP. And when we saw that the advice wasn't forthcoming, they were not attending courts, we took up their cases. And the best way to do that was to file the fundamental rights enforcement applications for them. So that's how we got to this tree, and that's also how we have done over the years. A lot of people are there who have not had their day in court formally.
So will these men be getting compensation?
As a matter of fact, we didn't ask for compensation. The one we did before this, we got compensation for them. It's one to get compensation, ordered by the courts. It's another kettle of fish to now go to the various agencies and get the physical, the cash, as it were, from them. Because a lot of times they tell you there is no money for that. You have to go all the way back to court again to compel the officers or the agencies involved for the compensation to come. So in this particular case, we didn't do that because we felt because of the level of overcrowding going on there, we needed to just get them out. We have so many other applications pending in so many courts as we speak to see how before the end of the year, quite a number of these people, especially long-staying inmates, can breathe the air of freedom again. So compensation normally comes in, should come in. The law has a place for that. So it's just a question of how do we juxtapose the need for them to immediately come out with the aspect of compensation. Sometimes once it gets to compensation, you will see the opposition begin to file all manner of applications saying no, when ordinarily they should not oppose the application. But because you are asking for so amounts from the government for them, you see them now come out and say no, we are going to oppose the application. A lot of flimsy grounds are now brought forth. And that's the real truth about the practice. So in this situation, we say, let's just get them out. Let them even breathe the air of freedom. After all, quite a number of other people weren't lucky enough to be alive to get to that day. Okay, but subsequently, we'll surely go on with that aspect, the compensation aspect. The law permits it.
All right, you must be highly commended for doing this because, as they always say, that it's better to have one innocent person go free. 9 innocent person go free. 9 guilty people go free than one innocent person incarcerated. Yes, that's the and truth. I say this because when this particular administration came into government and they were talking about reforms and decongesting the prisons, yes, there were talks about paying the backlog of fines for people that have been incarcerated and are in prison because probably they have not been able to afford these fines. Well, you are bringing a newer dimension. You are bringing another dimension to this. Why is there no focus on decongesting the prisons on the grounds of people that had not gotten their day in court or probably wrongfully accused or just found themselves in a bad situation, in a bad spot, and they got picked up by the police force and as a group and they found themselves where they are? Why are they not trying to do that as against trying to probably pay fines in the millions and multi-millions of naira?
Yes, that's a moot point you've just raised, and that is also part of what we as an organization are canvassing. Periodically, groups, the Chief Judge of Lagos here in Lagos and in some other states, from time to time go in when names are selected either by the MBA, when you have the MBA weeks for a particular branch, or when you have the normal, or call them jail delivery. They come in working with the staff of the custodial centers. Names are selected who they feel ought not to be there. For example, a person who is alleged to have stolen has stayed 3 years without trial. And now they look at it and say, if this man had been convicted, by now he ought to have finished serving that sentence. But now he has about just 2 months to go, assuming he was convicted. Such a person, such a name is always added in that list. But the point in answering your question is that those efforts are few and far-fetched. They are not consistent, because the truth is every day, every other day, working day in Nigeria, in Lagos, more people go in there than are released from there. So we need to double the effort. The focus is not there. That's the truth. And that is where organizations like ours come in. We call on partners, we call on lawyers. We are trying to set up a program now where we can get about 500 lawyers in Lagos only, volunteers, to work with us, take up cases, and especially the low-hanging fruits. We call these low-hanging fruits because when you get into the custodial centers and organize a clinic, you will see some people that will come out and tell you, "Sir, I've not been to court." These are not the hard offenses, as they are called. Robbery, armed robbery, murder, or that. These are, you see, they said I was arrested while working by 10 p.m. in the day. The police just came, they raided, like you just mentioned. And you notice that this man who has been here for 2 years has never gone to court. That's a low-hanging fruit. Some of them have gone to court 5, 6, 7 times, but nobody, no witness has ever been brought forth by the prosecution to say he did this. The police that arrested him are nowhere to give the evidence. These are low-hanging fruits, and this is what we see every other day.
So that's my question. So why is the government not focusing on that? Because that would actually decongest the prisons.
That is the truth.
Far more than saying that you want to pay fines for people that could not actually afford to actually pay some of these fines.
Yes, the lacuna is what organizations like us come to fill. There is an obvious lacuna, and that's the problem. Why don't they always do this? As a matter of fact, weekly, there should be weekly records. And we also notice something, even as an organization, when we go in there, we observe, sadly though, that to even get to the people who need our services within the center is difficult. Imagine end of last month, October, we were at the Ikoyi Medium Correctional Center, the Ikoyi prison, very close to this place. As at the day we got in there, the prison was holding 3,102 people. The board is there, you can see it when you go in. The capacity for that prison is 800 people. Wow. So 800 as against 3,100. And at the time you assess the office where you begin to do the clinic, meet them, you will see people, masses of people milling around. The truth is that in this 3,000, and you could see, I'm sure you could have about 1,000 of them that need our services. Now the problem is, how do we even get to know them? There is this gap. And that's where part of what we want to set up with the prison authorities is a system, perhaps an app, a software, where we can monitor those who have not been going to court. When organizations like ours come in, quickly they can say, yes, go to cell this, call so person, they now come. It will be easy for us to even assess them.
Okay, so now very quickly, I'm wondering, what is the way forward? Especially for what role should the National Assembly play in this? Do we need more laws? Or is it implementation of the already existing laws that we need?
I think we just need the very, very, very consistent implementation of the laws we have. Like we've always said, our problem to a very great extent as a country is not that we have outdated laws. Of course, we have that in a couple of places, but it's more of lack of the will to implement. Lack of the will to implement the laws. We have good laws. The Administration of Criminal Justice Act 2015 is such a wonderful piece of legislation. But up till now, I can tell you that you see situations where the police arrest people, like we just had this. These 3 men that you just saw, we are part of just the same people you see filling up the prison, pretrial detainees who are there, arrested by the police. Now, the law is that the police have to move their files to the DPP's office if the offense is of such a nature. That of stealing and all of those ones, no. But then the police don't do this, and that is an issue.
Hence my question to you, the role of the police in all of this, because you just said we've spoken about too many pretrial detainees.
Sure.
And the police can also help in probably handling some of these cases by sifting through, because if they were probably caught in a bad place at a bad time, and they found themselves in probably very, very suspicious circumstances, what is the role of the police in ensuring that some of these cases do not go that far, or some of these people probably are released at the police cell without actually going to prison?
Exactly, and that is where we need more strengthening of the role of the police. Incidentally, I have to say it, and that's the truth. Whereas the police is doing so much, there are still those bad eggs among them. We have to say the truth. And what do these ones do? By the time these young men are arrested, the truth is that you look at this matter, this is something that should not go beyond the police station. We have some groups also that normally visit this police station. The magistrates are empowered to visit at least once a month. But the police, because this is a day-to-day thing, they should look at some of these cases, caution them, or place them under watch, and then release them. But we see these ones who say, bring money, otherwise we'll go carry you, go court, as it were in the local parliament or local pidgin. And before you could say jack, the next day you will see the person, a charge in the hand of the IPO is brought to court. Last month, or early this month, I was in one of the magistrate courts to attend to some of these indigent inmates. And the magistrate had to lament. He told me, he said, Mr. Abraham, just before you came in, we had this matter where two people were just fighting. One of them went to police, reported the police, charged the other one to court. And then they came here, we can't even see the complainant. Some of these matters sincerely should not get to the magistrate, should not get to court in terms of the charge. There is something again I want to say in this context. The Lagos State Government, Ministry of Justice, began a very wonderful program. Now again, the implementation. And what is that program? The District Attorney Program. This is a group of people, they call them District Attorney. They are lawyers under the Ministry of Justice who filter, they act as a filtration system for cases, new cases that are brought to court before they are charged to court. The thing is that early in the morning or the day a suspect is going to be charged to court, he comes from police. The police come with them, the normal cases we have. When they get to court, they come with the charge sheet. They now give to the registrar who stamps and assigns to the court that will handle it. But the District Attorney Program, these lawyers have the office. The police will bring the suspect first to their office. They look at the charge. They ask the suspect. They now see the witness, the complainant. They have a meeting. At that stage, many cases could be settled, and the charge will not proceed to the court. This is exactly what this program is. But the truth is that it is not as effective as it was when it began. So you still see these flimsy cases ending up in court, and these people going in there to fill up that place. Someone was said to have been, we handled a case recently that they were demanding 150 naira from a motorist. Wow. And the motorist said they were not robbing me. They asked me, sir, do you have something? Even if it's 150, they were just arrested. Wow. Even with the protestations of the motorist, the police brought them to court. But the point is that if you have brought them to court, the issue is follow up the process. It's not just to charge them to court and everybody goes on. Adduce evidence, that's what the law says. If your evidence is strong enough to prove the charge, the judge or the magistrate will convict. We need the prisons to be mainly for people who are serving jail terms, not awaiting trial, pre-trial detainees. 80% and above of who you get, the people you see in there are awaiting trial. It's too bad for our system.
So let's talk about the bail process. You know, how easy is it to secure bail, especially in Lagos State, and especially when you look at those that are not from privileged background? How easy is it for them to get bail?
Ideally, the law provides that for a particular set of offenses, bail is as of right. Now, it's one thing for the court to pronounce conditions for bail. You get a shorty, bail is granted in the sum of 500,000. The law doesn't require you to pay 500,000, but to provide a bond as a shorty that when the defendant jumps bail, the shorty is arrested and forfeits that amount. That's the minimum. Now, to even get these shorties, and that's the problem, to process the bail and get it into action, which means this person has fulfilled the conditions and has left the custody, the precincts of the custody to his house, then going to trial from the house. That's a different kettle of fish. But something happened recently too. Section 12 of the Nigerian Correctional Service Act provides for the superintendent of a particular center to, upon looking at the number of inmates in his center and seeing that these inmates are beyond what the facility can hold, the law provides that he can stop admitting inmates. It happened in Lagos last month. The centers in Lagos stopped admitting inmates. Now, one of the things that happened from that, one of the fallouts was that the Chief Judge directed that bail conditions should now be lower than they used to be to afford these defendants opportunity to quickly meet these conditions and go home from there. So that's been on for some time now. But then the truth is that even with those conditions getting lesser or less stringent, the point still holds that some of the cases that even come there, that is for us, ought not to get to that point, ought not to come to the magistrate for the charge to be filed, the plea to be taken. We still believe that, like you earlier mentioned, at the point of the police, some matters can be dealt with. Beyond the police, then the district attorney program I earlier mentioned should be strengthened. By the time we have this 2 or even 3-part filtration system, at the end of the day, when anybody is now brought to take a charge, to take a plea in court on the day of arraignment, you could see that the charge is something that will end up, we could be looking at, say, 50 or 60% chance of success. But what we need is the cases to be going on, trial going on. The day you have your day in court, you go to court, go home, you have a lawyer, or your government provides a lawyer. Organizations like ours come to provide a lawyer to defend those charges. At the end of the day, the person has this day in court. That is what an ideal system should be like.
Ben Abraham, I want to say thank you.
It's my pleasure.
For your time here on the morning show and for the good work you're actually doing. Of course, Ben Abraham, a lawyer and also the founder of Zeraphat Aid. Thank you for your time on the morning show.